I want to start with an opening statement. Our wonderful videographer, Nick Yulo, has pointed out that the lighting may be a little different in each session because we are sitting in my office at the firm of Skadden Arps. It's on the 47th floor of 4 Times Square, magnificently located with a view of the Hudson River and the ball that drops down on New Year's Eve. But one wall is practically all windows. As we sat together yesterday, it was dark and gloomy and rainy. Today, we have a bright and happy day. So that does affect the color of the video. And while I'm on the subject of the color, I'll mention again what I said yesterday, that I was intending to wear the same thing all the time. Frankly, it slipped my mind what I had on yesterday. So I'm back to what I was wearing before because I did want to make my life one seamless web, and this talk of my life is one seamless web, but at least I haven't deviated from the core value of red and black. I've just kind of intertwined it a little differently. So that's my opening statement, and now we turn to serious business with Judge Mandelbaum. Robert, good morning.
Good morning, Judge. Let's talk first about the process of judging. How would you describe your judicial philosophy?
Well, the truth is, I don't think of my judicial philosophy. It's kind of something other people will define and do define when they read my writings. Every now and then, I used to be scandalized to see some attack in the press, which happened consistently, as I remember, after the election of Governor Pataki, that I was such a liberal-loving person and very bent on having every criminal defendant prevail. That would be a philosophy. That absolutely is not my philosophy. I've seen a philosophy more recently that I imposed single, unanimous opinions. That sounds like I bound and handcuffed my 6 colleagues on the Court of Appeals. Yes, I think we've referred to this a bit. We can come back to it. I did see a value in having a unanimous expression of the law when that was possible. Never hesitated to dissent. My colleagues never hesitated to dissent. That's a bit of a philosophy, I think, but I want to take a moment to disavow that bit of press as well, which is this is not the stuff of easy headlines, even in the New York Times, for which I have great respect. But the idea that one of us is liberal and the other one of us is not liberal, ludicrous. So this matter of judicial philosophy, that's a really hard thing for me to define myself. I think it's fair to say, and you were there for a couple of years, that I studied everything very carefully. I recognize that the cases that come to us, and relatively few cases come to us, and by that I mean relative to a trial judge in the state of New York, just unbelievable dockets, as you well know. The appellate division as well, huge dockets. The Court of Appeals, when I first came on the court, had 800 cases, about 800 annually. Far too much. Fortunately, the number hovers somewhere around 200. Everybody works very hard. So I would say as a first principle, reading, studying the cases, the facts, learning the law, and I was learning the law every minute of my time on the court. Sometimes I would scratch my head and say, this is such a fundamental issue. Hasn't this been decided like decades ago? Or, surely we've taken care of this years and years ago, but cases by definition get to the Court of Appeals when they raise novel issues, law issues of statewide significance. So even to the end of my 25th year, whatever, all those additional months and days, every brief I picked up, I was learning something new. And is that philosophy? I don't know how we define philosophy. I hope that I brought intelligence and dedication and diligence, because that is definitely at the top of my list for what's required of a judge. Fairness. we talk about having a rule of law that's stable and reliable and predictable. Very important when you sit on the Court of Appeals. You don't want a decision one way one day and the next way the next day. The Court of Appeals is a second layer of review in the state of New York. That's kind of a luxury to have a second layer of appeal, and then maybe even a third if you get to the Supreme Court of the United States is rare. But we have a system where there's built-in fairness and excellent trial judges and trial courts, and then a right to appeal to the Intermediate Appellate Court, which has very broad jurisdiction to correct errors of fact, as well as errors of law that the trial court may have made, and in addition, interest of justice jurisdiction. So there's a very broad layer of appellate review that is a matter of right in the state of New York. Now add to that you can get to the Court of Appeals of the state of New York. So obviously something different is intended in the design of our schedule, of our docket and our court system, and I had that very much in mind. Is that philosophy? I don't know, because I would have to put at the top of my list reaching a correct, just result in every case. Certainly, that is always the top of the list. But I also had to keep in mind that the function of the Court of Appeals, as opposed to other courts in our own state, is to, I think these are Cardozo's words at some point, settle and declare the law. These are legal questions that come to us, and so we have to have in mind the just result, the fair result, yes, but we have to have in mind the sequelae. We talked about that the other day. The fact that this is going to get carried hair by hair, whatever we say, to the next case and the next case and the next case and the next case. And we have to have in mind articulating a good, sound rule that will work for whether it's in the criminal context or the civil context, where parties can look to that as the law when they're planting their trees and planning their buildings and their contracts and their mergers. And, we want to know what the law is. We're not there to have the law one day one way and the next day the next. So are these judicial philosophy? I don't know. I think of judicial philosophy probably the way the headline writers think of it. Is this a liberal? Is this an activist? Is this a conservative? Well, I'm none of those. I bring no political predilection. I did not bring any political predilection to the cases in the court. But I have told you some of the things that were on my mind as I faced each case. And I must say, from my perspective, I was so perfectly situated at the Court of Appeals, doing the work of a judge of the Court of Appeals. I just loved doing that. But always, with the same sense of discovery in every case, I was learning something new, studying very hard, attempting to reach what is both a fair and a result for the parties and for society going forward. So is that a philosophy? I don't know.
You mentioned the care and attention that was paid to every case, and I actually had the joy of being with you for 3.5 years.
Wow.
Different chambers obviously had different methods and approaches to their work. Do you want to say a little bit about how your chambers operated
I do.
and how you used your law clerks?
I do. I'd like to say that in two respects. First, what I say is just about my chambers. I've talked about how close we are. We're physically close, but I think what a great design to have the court in Albany, basically 2 weeks out of every 5. So that means you're together like crazy for 2 weeks. I've told you that about our dinners together. Maybe I haven't, but yes, we and when I first came on the court, we had breakfast together early in the morning. That kind of went by the boards, but we're very, very close when we're there in Albany. And then we disperse around the state, and diversity is a high priority for appointment of judges of the court. Diversity means not only race, gender, ethnicity, it also means geography. And so the effort, because you want representative views when you're considering cases, and so there was always a desire to have geographical diversity. But we would come together in Albany basically for 2 weeks out of every 5, and then we would disperse around the state basically for 3 weeks out of every 5. That's how the court worked. Now, some people viewed the session, maybe the public, the session as when we were working and then we're home and kind of luxuriating for 3 weeks. No, no, no. When you're home, that's the time you draft the opinions, and I've told you the seriousness with which we took that responsibility in order to meet a self-imposed but very important schedule of hearing cases one session, deciding them the next, and handing out an opinion. It was furiously, furiously busy in chambers for those 3 weeks, both working on writings on the cases we just heard and studiously preparing for the upcoming cases that would be argued the next session, and handling the innumerable other responsibilities, reading and writing motion reports when cases that where we had discretion to bring them to the court, and considering criminal leave applications. Those were the basic fundamentals of home, of being at home. During the 2 weeks that the court was in session in Albany, we were very close to one another. During the 3 weeks that we were at home, maybe we would exchange a lot of drafts. You'd get your draft out on a writing and you'd hear from your colleague with a markup or a phone call. But very, very little communication in the 3 weeks. And so I say the design was kind of inspired for a really good collegial court because I could never wait to see them. I was so excited to see them. I had a sofa in my chambers at 230 Park Avenue, and the day I arrived back from Albany, I would begin accumulating things to take up to Albany for the next session, always looking forward to being with them. And the day I arrived in Albany, I began accumulating things on the sofa to take home because I knew after 2 weeks together, arguing every single day about cases and points of law and motions and things like that, that I would be very eager to give them a hug and say farewell. And that's really how it worked. And I look at the Supreme Court of the United States where they're together all the time, and I'm thinking, maybe it's kind of nice to have those little breaks because I think it does encourage that very great personal warmth that we enjoy. But to get back to your question, and I'm taking a very long route around answering your question, what took place in my chambers took place in my chambers. While we enjoyed the personal collegiality and all that, I honestly have no idea how the other judges prepared their cases. We just never talked about that. It was to each his own. That there was the expectation was a very, very high level of preparation. How you got there, I don't know. And indeed, one of the delights of oral argument, and let me tell you, are we going to get to oral argument? Because I don't know whether it's my particular bent as a litigator or whatever, but we'll get to that. That oral argument I regarded as a particularly pleasurable occasion. But for the moment, it underscores what I'm telling you about the operation of chambers, because until the case would be called for oral argument, and the attorney would stand at the podium and say, "May it please the court," and then the bombardment of questions would come from the other judges. I had no idea what was on the mind of my colleagues about a particular case. We never talked about a case before we went on the bench. There was no internal law clerk court document that came from somebody. I think probably some benches have that, where you get some kind of bench memo that takes a particular position. We would get a report from our consultation clerk, and the report was valuable in one sense. It essentially just repeated the points that were in the brief, the major headings in the brief. It was completely free of any view of the case, but there was one really important thing that those reports did that came from the court's consultation clerk, and that is there would be a footnote, sometimes a very substantial footnote, if there was some technical impediment in the case, some jurisdictional impediment because there are a lot of statutes and rules concerning the jurisdiction. To give you an easy one, a case has to be finally decided by the court below. Usually I say the appellate division. Maybe there would be a time where somehow the case got to us, maybe on 2 dissents at the appellate division where a case automatically comes to the Court of Appeals. Maybe for some reason the lack of finality eluded the parties in the briefing, eluded somebody that, and so we would always check those reports to be sure that there was not some technical impediment to the case being before us. But other than that, each chambers operated separately, got our own sets of the briefs, and in my chambers, this is what we did. My law clerks, it was originally 2 law clerks, then when I became chief judge, 3 law clerks, and then with the advent of the death penalty adding substantially to the calendar, it became 4 law clerks. My law clerks would divide the cases among themselves. And I honestly don't know how they did it, but we'd get back from an Albany session with these like banker's boxes of briefs, which would be the briefs for the next session a month later. They'd arrange them on shelves. This is the first thing we did when we got back from Albany. And they would, among themselves, divide up the briefs in a way that, and the cases in a way that they thought best. And then they would do, each of them, intensive investigation and preparation, and prepare a very thorough memorandum for me. And in addition to my studying the memorandum, I think I made it a habit to take briefs with me wherever I went. Maybe get a long red light someday. Maybe get stuck in an elevator. Always good to have a brief. I still do that. I don't, unfortunately, have those wonderful briefs to take with me, but for me it's necessary always to have some important reading material, just in case. So I would then begin working with that law clerk in particular on that case, getting ready for the upcoming argument. And in addition, I had the wonderful tradition in my chambers of almost every day lunching with my law clerks. Now, I just loved that because we would sit around the table in the conference room that I had, and I'd say, let's do a case. And so whoever had a case, and then this would be with the other law clerks who had really no exposure to the case. And we would pretty well hash out the cases. So by the time I got to Albany, I think I was quite well prepared. But that's how I did it in my chambers. The intensive preparation, individually with one law clerk and then with the law clerks together. The oral arguments go on at 2 o'clock every day. Before at 12:30 generally, you're back from conference in the morning, argument in the afternoon. So you're generally back at your desk by 12:30, getting ready for oral argument, which wonderful Cedric, who was our court clerk at one point, he called it showtime, and I started to think of it as showtime. But I would sit with my law clerks, the one who had the case, or happily the 4, if they would sit with us, to go back and forth and say, the point of the oral argument is, what things do we really need to find out? That's what you're doing at oral argument. What do we really need to know? What questions do I need to ask? And as I said a few moments ago, it would be the first time I would hear from my judicial colleagues, and sometimes there would be that aha moment, where something I hadn't thought of, that I'd hear from somebody else. Occasionally, if you watch the arguments, you'll see, very rarely on the court, but sometimes the judges will be going back and forth between themselves, where they each have a little different view and they're taking it out on the lawyer. So that's generally how cases proceeded, and before they got to the conference room. How do you want to continue this?
Well, we'll get to the conference room in a moment.
Okay.
But let's talk about arguments while we're there. What was your questioning style?
A couple of things. First of all, I've told you that for 21 years I was a litigator. So I had, I think that usually my questions were unobjectionable in form. That I always kept that in mind. To ask, there are a lot of rules about not asking compound questions and all sorts of things. And sometimes I hear judges asking these convoluted questions, and I want to say that question is improper in form. Would you restate the question? Which, of course, I would never do. But there's a reason for the kind of rules that we have, and the truth is, when you ask a simple, a simply phrased non-compound question, you get the answer rather than the furrowed brow and a look of confusion from the lawyer. So I did not believe in using oral argument for interesting exchanges with lawyers about things I've always wanted to know. I tried to keep the questions relevant. I also didn't feel it was necessary for me to take over or to ask the first question. I thought we're 7 equals up there, and anybody who wanted to ask the first question was free to ask the first question. I told you that I had never argued a case at the Court of Appeals. I had some that were summarily decided on the summary procedure that the Court of Appeals had. I have to tell you, the first thing I did as a judge was to go to the file and get the reports on those cases. They were wrong. I say that I really just treasured, we all did, oral argument. And I just want to linger for a moment on counsel standing there, because I very much felt the burden of counsel, and especially if, like, the client is sitting there, and and you know what your night is going to be like anyway. There's the story about the 3 arguments you make: one the night before, one the argument you make, and one the night after, and. So I know how you torture yourself. And the other thing that to me was extremely important was the courtesy. I've talked about the collegiality, the courtesy toward counsel and between counsel. Don't think I didn't notice when lawyers shook hands at the end of their argument. I did. They're not there to just punch each other into the earth. And there should be the same kind of courtesy from the court. I can't imagine cutting a lawyer off. I think it's important to keep within time limits. The time limits are very carefully set. The chief judge reviews the calendar with the clerk of the court. You start doing that a month before, figuring out which cases are going to be on which day. You may need to pair a couple where the issues are similar. There are a whole lot of fine points that go into setting the calendar, and then setting argument time. And honest, you do the best you can. I remember when in an earlier time, 10 minutes for an argument would have been kind of when we were dealing with hundreds more cases, and we'd have 7 or 8 cases a day on the calendar and sit there till 6 o'clock. So 10 minutes, it went to, I think, about 15 minutes is sort of average, and sometimes you get 20 or 25. It's very important that counsel be mindful of time limitations, but the court too, and not cut people off. And I just can't think that the Court of Appeals ever would do that because of what it takes to get there. I mean, in terms of the money that's spent to get there, the time and effort that are spent to get there on both ends. Now, you have to be careful, and this was something that particularly it falls to the chief judge, because the chief judge sits there with the opportunity to say enough, and you want to not have the privilege abused. That's very important. There should be respect for the court and for the other parties who are going to follow, and you shouldn't abuse if you have 15 minutes, you should plan 15 minutes of argument and be sure you use them all well. And if you don't have 15 minutes worth, but 13 minutes, don't stand there to say, and as I said before. But the same is true for the court. If counsel is in the middle of a sentence, I couldn't think of anyone cutting off a person in the middle of a sentence, but even if you're at the end of a sentence and you say, Your Honor, might I just have a moment to complete the thought, especially when there's been lively questioning. Because when there's been lively questioning, it means counsel has been taken off the points that counsel thinks are the most important points. And really, that matters less than what the judges think are the most important points. Nonetheless, a fair and reasonable opportunity for counsel to say, complete a sentence, complete the paragraph. I think that just signifies that gives the message of the kind of place the Court of Appeals is. That's what I think of oral argument.
You mentioned something quite interesting with respect to oral argument. I'll ask you a compound question about it. You said that sometimes the parties were there. How frequent was that, and how did the judges feel about that when that happened? I remember
Well, I guess we couldn't tell. First of all, you can't tell. I used to joke that sometimes, there's the counsel table, which is the closest to the bench. And by the way, something very significant at the Court of Appeals, which you don't see in other courtrooms, is that attorneys, when they argue, are at eye level with the judges. What a statement that makes, doesn't it? But there's a counsel table at each side in front of the bench, and sometimes and there are 3 or 4 seats on each side. To the right of the bench, the appellant; to the left of the bench, the respondent. And I used to joke when it was just one lawyer arguing that the other 3 would come up to tell the person on the way back from Albany home that they did a really great job. That was the purpose of the companion people. So I always assumed that they would be the more junior attorneys, and really they're there not just to tell the person that he or she did a great job, but what if something comes up that's unexpected? What if the court asks, where in the record can I find that? These are things that happen. You want to know that you have somebody there to give a ready answer, to underscore your credibility as counsel and the credibility of your position. The audience, we usually had a reasonably full audience. It pained me always to think that the only people who came to the court were the lawyers making argument and perhaps the parties, but that, for example, Albany Law School students, oh my goodness, or students from the area, why they wouldn't come to watch? What a bafflement, really. And they should be there. And members of the public, I think they should come a little more often too, to be involved in more ways than as critics. If there's a decision that's not quote unquote popular, then you'll hear flack about it. But people don't come really to learn and I would think to understand and appreciate the justice system and the court. So we wouldn't see a lot of people in the courtroom. We would not see, and that I think was sad because oral arguments were always something that the judges looked forward to, and I think the public more too, should more too. And I will say in this connection that for a while, all of the arguments of the court are televised. That was never an issue for us as it is for the Supreme Court of the United States, which I cannot for the life of me understand. Technology is such today that you're completely unaware of the cameras. They don't interfere at all. There may be some very sound objections to, and there are, to televising trial proceedings. But I cannot for the life of me understand why there is any objection to televising the proceedings of an appellate court. And for a while, our proceedings were not only televised, but also broadcast within the city of Albany. And I remember one treasured evening going into a restaurant in the city of Albany and having a woman come up to me and just clasp my arm and say, I watch your arguments every day. I put up my ironing board and I do all my ironing in front of the arguments of the Court of Appeals. Pretty nice. That's a lot of ironing anyway. But I can understand why it might not be everybody's favorite daytime TV, because at the Court of Appeals, the proposition, I say we're a law court. We exist to determine issues of law, and when people get sidetracked into the facts, then one of the judges, usually the chief judge, will say, we're familiar with the facts, would you stay with the law? And I always said for all that one day I would, and I didn't, say, which is more likely true, we're familiar with the law, would you just stay with the facts? Because the facts are almost invariably more interesting than the public would find the law. But the show got dropped, and so the public can't remotely watch the Court of Appeals. The public in the Albany area can come in any old time. And in fact, when school groups are there, we always know, and we're informed ahead of time. And a judge from the court will go down in advance of the argument and spend a few minutes. I always loved to do that. That was a favorite time for me to answer questions that people had about the court. But I come back to the point, not enough people do that. Not enough of the public learns, and they should. They really should know more about the courts.
You reminded me of something else that you always said you wanted to try to do, but which we were never able to manage to do, which was to write an opinion without any citation to a case. Do you want to talk about your writing style a bit?
Okay. My writing, I think, first of all, the premium that I place on writing, and especially as a judge writing an opinion. You have to be very, I think you have to be very, well, I'll say careful, although careful was not the first thing on my list. The first thing on my list was to state articulately what the decision of the court was. That's really the most important thing, to articulate the law clearly and correctly. And I got to be, I think, the president of the first paragraph club at the Court of Appeals. Maybe that goes back to the training as a journalist and the importance of the lead paragraph. I tried to put the issue, the holding, the result in the first paragraph when that was possible, but never, not make a fetish of it. That was not the most important thing to do. But I always thought that opinion should be readable and understandable, comprehensible, and aimed for that without rhetoric and flourishes and the kind of pepper you sometimes see. I think some judges maybe go back and pepper their writings with things that will make them famous. I think what makes you famous is to, if that's what you want to be, is to do a good job articulating the law. But you've reminded me that there were times that I thought maybe to achieve that objective, it would be nice just to have an opinion in plain English with no case citations. But that never was possible because the court is very, what you're there to decide are issues of law, and invariably they have precedents. They have roots in the law, so you have to get into those, and they have sequelae, so you have to get into that. And so a court opinion from the Court of Appeals is necessarily not your everyday reading. It's everyday reading for lawyers and judges. But at the other end, when I talk about making it readable for the public, I've seen some judges who have written decisions in poetry, and I think it's. And I've told you I also don't believe in using salt and pepper in to make opinions distinguishable that way. So I don't know. What do you say is the bottom line?
For your writing style?
Yes.
Well, certainly clarity, no Latinisms.
No Latinisms, as few semicolons as possible, as little punctuation as possible. I think sentences should carry their own weight, and you should use your words carefully and sparingly, and not need to dress them up with a lot of punctuation and a lot of rhetoric.
And certainly you paid attention to every single word
yes,
that went into it.
Absolutely, because words, even commas, can come to haunt you in later cases. So you have to be. It wasn't just for the vanity of having a well-structured opinion. It's because you can get hurt, the court, by opinions that are not really very diligently crafted, every sentence, every word, every comma. Mm-hmm.
The conference room.
The conference room. So I've taken you through the oral argument, and assume that we've just heard arguments on Tuesday. And forgive me, I keep using the word we. I'm never going to get that out of my system. But there's one little step before the conference room, and that is when the judges leave the bench that day, they go to the Red Room, which is a small room behind the courtroom. And on a table in the Red Room will be index cards turned face down. And in order of seniority, each judge will pick one index card, which will contain the name of a case that was argued that day. And that makes the person who picked that card the reporting judge. The reporting judge takes principal responsibility for that case at that moment. And that means a difficult evening because you go back to chambers very late in the afternoon before dinner and sit with and again, I'm telling you what I did in my chambers. I don't know what the other judges do. But we would sit together, especially, first of all, I would have to prepare a vote on every case because every case was going to be conferenced the next morning. But I would have to be particularly careful about the case where I was the reporting judge and held the card. And for me, until the last day I was on the bench, I would try to write out in outline form what I intended. You would have to start at the conference table when that case was called the next morning with your recommended result: affirm, reverse, dismiss. I can't, maybe other things too, and in an opinion, which would mean a signed opinion, a per curiam, which would mean an opinion. Opinions and per curiam opinions go in the front of the book, the Court of Appeals book, but the per curiam is unsigned, and with matters of attorney discipline, judge discipline, you wouldn't want to put a particular judge's name on it, a per curiam opinion, or a memorandum, which is an unsigned writing, generally at the back of the book. So you start your report with affirm in an opinion for the following reasons. And then you go through your report, a little tiny bit of the facts just to give a premise. And then you do a quite detailed report on the law. This is what I would write, in my opinion, if you all agreed, or at least 4 of you agreed, or 3 of you agreed with me. And so I'd complete my report as the reporting judge and go to the junior judge. We start in inverse order of seniority and work around to the most senior judge. And that was the system when I got there. And so far as I know, it continues to be the system. The idea being that the junior judge, the newest judge on the bench, should not feel somehow cowed, although, believe me, nobody ever does, by the more senior judges by the time you get to the Court of Appeals. So in inverse order of seniority, each judge casts a vote. If there are 7 easy votes to affirm, as recommended by the reporting judge, the case is put over for a writing. But that's after a quite full discussion. Each judge adds, I think, Judge Kaye, I agree with Judge Kaye in result, and I'm overwhelmingly for the grounds that she's recommended, but these are the things I would add, or this is where I think we should not go because we're going to get into trouble with XYZ body of case law. A very, very informed discussion. By the way, you may hear the echo of a phone every now and then. I've told you I'm seated in my office, and we've turned off the phone, but there are echoes every now and then. So it goes. There's a very full discussion of the case as it goes around the table, and if on a good day, if everybody's to affirm essentially for the reasons that I had reported, the case is then put over for a writing, and that's the last you'll hear of it. It's hard. Most cases have somebody who's got some difficulty, problem, which may be resolved in going around the table a few times. It may not. It may have to go over another day or another day after that. The court conferences every morning from either 10 o'clock or 9:30 in the morning until 12:30, until it's time to start preparing for the 2 o'clock oral arguments. So then take the other example where I, the reporting judge, go through my careful and well-reasoned report, and the judge seated immediately to my right, the junior judge, is the other way, always starting with the words "with due respect," and we all know what that means. It means you're wrong. So the judge will give a very detailed explanation with a little extra burden, knowing that now the judge there's disagreement, and the judge, everybody is an advocate in addition to being a judge, because you've worked hard to develop your recommendation. You want to prevail, but you want to be reasonable too. And the case again proceeds around the table in inverse order of seniority. If the junior judge carries the court, the junior judge is going to get the writing. And then, again, this is a case that's going to be conferenced probably a couple of days. And it may wind up with the junior judge in getting the writing, and then I would have the option to dissent, to say that I'm going to dissent, or to say that I'm going to wait and see the junior judge's writing before I make that decision. And essentially that's, in brief, how the conference goes, and that occupies every morning, a full morning in the conference room. The clerk of the court sits, as well as the consultation clerk and an assistant consultation clerk. And the reason for those people being there, and they keep very careful track of what the votes are and all, and the discussions. They are not part of the case resolution. But there are many, many technical rules at the Court of Appeals. I've already told you about the final decision. Sometimes things get by that even the most careful readers have not seen, and the consultation clerk may say that we're overlooking this can't be first degree, this has to be second degree, or some technical observation. But mainly the consultation clerk keeps track of the flow of the discussion.
You mentioned advocacy. How did your experience as a litigator help you or come into play in the conference room?
Well, I always saw the oral argument, my reporting, as my 10, 15 minutes of oral argument before the bench. I mean, here I was advocating for a position, surely in a different role from the lawyer. I mean, I was the lawyer says this is the law of the state of New York, or should be the law of the state of New York. But here's a judge saying this is the law of the state of New York. It has a little more force, a little more power, authority. But basically, you're making the argument that the advocate has made, hopefully in a very, very convincing way, that you've diligently persuaded yourself that that's the correct result, and that's what you're urging the court. You're advocating that for the court.
You mentioned that you wouldn't know what your colleagues were thinking before argument. What about after argument? What was the interaction like between chambers? Did the judge discuss the cases?
Well, there's a very interesting history here, and I'll just spend a minute on that. I came on the court in 1983. And I can never forget the first day I was there, and I was in my chamber, and at the time there were 5 judges situated. They had their chambers in Albany on the second floor of Court of Appeals Hall, and the 2 more junior judges, the most junior judges, had their chambers on the third floor of the Court of Appeals. And I remember my first day there, sitting in the chamber. Judge Simons was in the chamber next to me. But it was Judge Jones who came into my chamber and said, he greeted me and was so happy that I was there and all that. But he said, you better get a lock put on your desk. I thought, oh my goodness, a lock put on my desk at the Court of Appeals? Unbelievable. I couldn't have imagined that. But I don't know. So there must have been a kind of feeling that I don't know whether there had been an incident. I never investigated that. But that just indicates a certain level of intensity about privacy. And the other rule that they very strictly they made known to me and pretty strict, I'm using pretty strictly instead of very strictly enforced, was there is to be absolutely no discussion of a case outside the conference room. I say there something must have gone on, and there must have been some judge who just talked a little too much. I don't know. But that was we when we're at dinner when we were at dinner all the way to the end, we never talked about cases. We talked about the lawyers. We talked about our personal lives. Essentially, the place where the case discussion takes place is at the conference table in the presence of everybody. That is the goal, the aim, the aspiration. Now, however, I said pretty well. Judge Simons and I, and if we had to put these ugly, kind of liberal, conservative kind of labels on ourselves, he probably would have said that Judge Simons was more pro-prosecution and I was more pro-defendant. I say I really resist that, and I'm sorry to put it on myself, but I remember when Judge Simons left the bench at age 70, and we were very dear and remained close friends, I remember his quote in the Law Journal that he and I probably battled more, that was his word, battled more than any other two judges. And we did battle a fair amount about the cases. You mentioned Bing the other day. He prevailed on that one, but there were others where I prevailed, and they were the most serious, informed arguments over we just often didn't quite see eye to eye on these cases, but we both had enormous respect for one another. But we developed this sneaky little procedure. We were both on the third floor. And maybe it was just to get a little bit of exercise, although I have to tell you, I started early morning runs when I was, and Judge Wesley and I especially, ran 3 or 4 miles every morning before we'd get there at 5 o'clock in the morning, but that's for another day. But anyway, Judge Simons and I began walking up the stairs after oral argument, and guess what we talked about? Not that it made any difference to us. It was just nice to know going in to the conference room the next morning. I would know if I was going to report to reverse a criminal conviction, I would know already that Judge Simons was going to affirm it. And I guess I could have told just from listening on the bench, but we did talk about the cases on the way up the stairs. And you can have no better evidence that this didn't influence anyone's vote than to look at the times that Judge Simons and I publicly disagreed about cases. But the rule, and it's really quite it's well and strictly observed, is that the cases are discussed in the conference room. Now, one of the recognized exceptions is a case, I wish I could remember, but it was a very important commercial law case, and I'm using this to typify what I'm about to tell you. It's a case I think of as shuttle diplomacy. It was a case where it was especially important that there be a unanimous court. It's a big principle. There was a sharp division. It wouldn't have done the law any good. And there were 1 or 2 judges who undertook, quote unquote, shuttle diplomacy to achieve what eventually became a unanimous opinion, and I note from time to time continues to be well cited and has not caused any difficulty. So, while the overriding climate is one of decisions only around the conference table, there are times when it's desirable to take a couple of extra steps. And we all knew this was going on. I was not part of I knew it was going on. I was not part of it. But 1 or 2 judges saw that there were possibilities that we could reach a single result, and it was desirable to do it, and we did it. So that's my statement of the overriding proposition and the every now and then exception.
You mentioned that case being a particularly important one in which to reach a unanimous result. Can you talk about the court's approach to which categories of cases there was a particular striving for unanimity when possible, and why those categories, cases of statutory interpretation, and which cases made more sense for there to be a divide when necessary and not? And
well, I'm not sure. Yes, I'm not sure that I can state categories, but you've just used the word Judge Jones's article. So naturally, you've reminded me of the article. It was his Cardozo lecture called Cogitations on Decision Making. And he does express the view that dissents should be cautiously used, and when you're going to dissent, let it go, let it all out, but just use them wisely, intelligently, and cautiously. Now, what categories? I can't think of any particular categories of cases. I guess the overriding objective was the clear, a sound result in the particular case and a clear articulation of the law, hopefully in an opinion that represented the views of all of the judges. What am I missing about and yes, and something does occur to me that I do want to say, and that is generally there are three kinds of cases that get to the Court of Appeals. And today the overwhelming category is the category of statutory interpretation, where we take a statute of the legislature. We talked about register, statute enacted by the legislature, and we try to give it the significance. The statute maybe was adopted in 1900 or 1925, or maybe it's just lain fallow for decades, and nobody's suddenly in modern life somebody's wondering what on earth this means in the tech age, or it's got a whole new application. And we work hard to figure out what we say all the time, and we really, really, really mean it. We want to interpret, to have the will, to state the will of the legislature. We want to apply the will of the legislature. That's what we're doing in issues of statutory interpretation. And I say hopefully we can reach one view. We try to reach one view. It's not the end of the world so much if we don't reach one view, in the sense that if we've gotten it dead wrong, if that's not the intent of the legislature in the year 2011 or whatever, the legislature can rewrite the statute. That's, I say, not the end of the world. The second category of cases we have at the Court of Appeals are what's known as the common law. This is what I referred to earlier as judge-made law, which these are cases where the judges themselves, and typically the judges of the High Court, the Court of Appeals, will say what the law is. The most common examples are in the tort cases, in the personal injury and property damage cases, where the court will set limits on what's proper and what's not proper, and draw the lines on what the duty is, and that tells the public what the duty of the building owner is with respect to sidewalks, or that would be the most familiar sort of thing, and the court says what the duty is or what the law is in the common law tort area, and maybe as time goes on, that doesn't, circumstances arise and it doesn't quite fit anymore, and I had a powerful lesson, very early lesson in that from Judge Jones in a case involving damages for personal injury, where a mother was seated in an automobile, and there was just a terrible accident. She had her infant in her lap. The infant, I believe, died, but very seriously injured. But there was absolutely no physical injury to the mother. The mother was totally unharmed. And the issue, the lawsuit was brought including a lawsuit on behalf of the mother, and I'm sure other parties as well. But the question was whether she could recover for emotional harm, that is, the horror of having her infant so severely damaged and maybe even killed, whether she could recover damages when there was emotional injury but no physical injury. There was no physical injury. And the Court of Appeals had been very articulate about and very clear over the years that you needed some physical injury in order to recover for emotional injury. And I think that was a way of just limiting the universe. Otherwise, for people to just say, I get bad dreams at night because I watched some terrible accident, you'd worry that then there would be runaway damages. And I researched the law pretty carefully. And I thought, sad as it was, tragic as it was, that claim had to be rejected because there was no physical injury. And so we couldn't just allow emotional injury. And I remember when that case came to the court, and again in my early months as a judge, the reporting judge was Judge Jones, who was either 69 or 70 years old, and about to leave the bench. And I say enormously respected it, as every one of those gentlemen was at the conference table. And Judge Jones just knocked my socks off when he reported to overturn the lower court and allow the claim to proceed. I was aghast. It took my breath away because I studied all of the cases so carefully, including the cases of the Court of Appeals, and clearly that claim was not allowable, just not allowable. I listened to his report, and actually what he was proposing was that the claim should be allowed for what's called bystander emotional injury, that is a bystander to an accident, only when it is a close family member. He drew the line on close family members. But even so, I thought, this is just outrageous. And so he made his report, very fine report. And when it came my turn, I was the next to speak, the junior judge. I just collected myself. I couldn't believe what I had just heard. And as I've told you, it came as a shock to me. We didn't know ahead of time, any of us, what the others were going to vote. Except I knew that Judge Simons was with me, which was to say, no way. I knew that from our walk upstairs. See, it gave me a little more confidence in my report, knowing that there was one other judge with me. But neither of us figured on Judge Jones. So it came my turn, and I gave the report of a lifetime. I had it all written out. I knew all the cases. And I think that was another instance where Judge Jones, when he had the opportunity to respond, began with due respect, Judith. I think so. Because he said, in as nice a way as possible, he said, I know the law of the state of New York. And wow, I don't think there was anybody who knew it better. He said, but I think the time has come to adjust that rule just a little bit. And what I'm proposing is a very modest change. It's not going to open the floodgates because it just would be limited to close family members. He recognized the possibility if the court suddenly said, we don't care, just emotional harm is enough, that there could be just a run on the courts for anyone walking through Times Square who saw, some injury to a person that, said, now I'm suffering mentally for the rest of my life. Could you believe it? The four 70-year-olds went for the new rule. Unbelievable. And I wrote the dissent, joined in by Judge Simons and Judge Wackler. The three junior judges were the old fogies on the court, and the four 70-year-olds took the law into a new chapter, very cautiously, and I might say in retrospect, correctly. So that's my second example of the common law, where, again, like statutory law, you can make change over time to accommodate societal change and new problems. So in the first instance, it's the legislature that, quote-unquote, corrects an error, or at least better expresses its intent. In the second case, the common law, it's the judges themselves who adjust the law. And of course we have so many instances of that. And my great hero, Benjamin Nathan Cardozo, I mean, when you just think of the times he did that just to give you one tiny example, the McPherson case. I mean, these are all cases that law students know so well, where it took Judge Cardozo to observe that an automobile could be a dangerous instrument on the highway. You know, that it was, and to adjust the duty principle to allow recovery for negligence in, I think it was tires or some part of the automobile, so that plaintiffs could recover against manufacturers for negligence, whereas under the rule before McPherson they couldn't. Kind of an analogous to the case I've given you, Bobson against Sampieri. That's the second category of cases before the court. The third category of cases is the category of constitutional law cases. Yesterday we talked about state constitutional law cases and federal constitutional law cases. Here it's hardest for change. In the one sense, we have a lot of undefined concepts to deal with. Our framers particularly used those phrases: due process of law, equal protection of law. You can't give a dictionary definition of those phrases. It depends on the case and the time and the circumstances and the situation, and these you know, even some of the very explicit language over the years that the framers didn't intend for us to apply circumstances as they existed in the year 1777 or 1789 or 91 or 1938. No, they intended for us to give meaning to those principles for living people in the modern world. That's what we're there for, not to go back to 1777. But here in this third category, what gives a greater pause, although it should be clear from everything that I've said that we give a lot of pause in every category, but change is very hard. You can't rewrite the statute. You can rewrite the statute. You can rewrite the common law principle. Much harder to rewrite the Constitution or to go back on something you've said when you want stability and rationality and predictability in the law. So in that third category of cases, I'd say there's that extra pause to just be sure that you got it absolutely right.
Are there any cases you'd identify as among the most difficult you dealt with, any that you're most proud of? Any
Oh my
regrets?
goodness, oh my goodness. Well, first of all, I learned not to have regrets. You just have to be bold and do what you think is right. That's what you're there to do. That's your responsibility, and you can't just relive and be regretful. So I'm taking that off the list. What do I and to say most proud, I would have to be picking one of my children. Every one of these cases is, very dear to me, and I mean, but I guess in the past, I'll tell you just a couple of little stories. I told you the other day that how thrilled I am when someone comes up to tell me what a change in his or her life the same-sex adoption decision meant. That just makes me feel very pleased. If the dissent in Hernandez budged by even a millimeter public consciousness about issues concerning same-sex marriage, that pleases me very much too. But just on another plane entirely, I live on the Upper West Side, and one of the early cases that we had concerned something that makes law students just nauseous, and that's called the rule against perpetuities. It's really just weird and odd and very difficult, concerning succession to land and use of land. It shouldn't be tied. Basically, the idea is we shouldn't be unnecessarily tying up property. And so there's this rule against perpetuities. And in my early years on the court, we had one of those cases involving a property called Symphony Space, which is on the Upper West Side. And I pass it every day, not every day, but very, very often. And if the owner of that space or somebody who runs the programs, it's a wonderful public space. Lots of great things happen at Symphony Space. But back in the early 80s, we had a case involving the rule against perpetuities as it applied to Symphony Space. Someone was claiming a right to take over that space, which, owing to the Court of Appeals decision on the rule against perpetuities, which I wrote, saying that they couldn't take over that space. Today we have Symphony Space, and so they never hesitate to. When I see them, they're, oh, Judge Kaye, Judge Kaye. And I have the same feeling on the few occasions that I go to the Four Seasons, where the restaurant, very fancy restaurant in the city of New York, it was just kind of interesting. I started to say, what fun, but we had a case. It involved the landmarking of the interior of the restaurant. Just think of that. I mean, we have so many cases involving exteriors of buildings. And you can see where you would landmark the exterior of a building. That's hardly the end of the world. But imagine landmarking interior space. You know, don't move that vase or you're going to violate the law. Well, we didn't get down to that sort of thing, but it was just the basic design of the interior space at the Four Seasons restaurant. So when I'm there, I think about that too. And so I say what pops to mind are some little things, because the Court of Appeals, plainly, we have cases involving, the adoption of a child, and that reminds me of another. Well, see, we'll just go on and on like this, because I refuse to pick out a favorite case or a most significant case, but I can tell you one that caused me the most tears, maybe not the most, but a lot, involved the adoption of a child whose both biological parents were mentally impaired. And these children, the case we got in the Court of Appeals was only one of the children. There was another child, too. And shortly after the children were born, there was a proceeding to take them from the parents, which failed. And the reason it failed was that a pediatrician, psychiatrist, I can't exactly remember, testified that he thought these people with significant assistance could manage the care of their children. And the case that came to the Court of Appeals some years later, which still is making my spine chill, was another case to take the one child from the parents. The other child had already been taken, because that same pediatrician, psychiatrist testified now that even with huge supplemental resources, these people were just unable to care for their children. And I remember having the transcript, having everything about the case, and going into one of my rooms and closing the doors with a huge box of Kleenex, because we upheld that decision. And I could only think how painful that was for those people. Like, it had to be the end of their lives to have their children taken from them. But he said after 5 or 6 years, it was clear that they would just never be competent with however much help they had. And the one child was removed from the home. And I do remember adding one footnote that was kind of in the none of my business category, which was to underscore that the effort should be made to keep those parents, and especially to keep the brother or sister, I can't remember which one was the subject of the prior proceeding, attached, to keep them attached. And, we don't do that, or at least we didn't, and I don't know whether it's different now, but it just shows you the range of things that come to us, which that come to the Court of Appeals. But that case certainly stands out for me in terms of emotional drain, and not to say it didn't happen many times. It happened. You have to sometimes, and you asked me before about regrets, and I told you I don't live with regrets, and you can't. I don't think you can have a thick skin and be a judge. You have to have a thick skin in the sense that you shouldn't live with regrets. What you've done, but you have to be thin-skinned to understand that you're affecting the lives of human beings very profoundly. So I'm not going further than that with favorite cases.
Did your approach to judging change at all over 25 years with your experience?
Again, I think we're kind of in the area of other people's evaluation. I remember the time I was attacked at the outset of the Pataki administration. I've gotten those articles, and I remember how painful that all was. That was so unfair and wrong and painful, being attacked as the criminal-loving liberal. I just had to bite my tongue and go on. I was neither a criminal-loving liberal nor, as people have said of my later years, evolved by reason of all of those attacks into a conservative right-wing kind of thing. I think both of those are utterly ridiculous. I think I am what I am, and I don't think I've changed, and I think I've tried to reach a fair result in every case from the beginning to the end, and I don't think it's fair to put me at any on the spectrum at either of those absurd ends.
Are there any other reactions, public or private reactions to your cases that stand out besides Aunt Libby's that you mentioned yesterday?
I'm not sure I gave you my whole Aunt Libby reaction, but this tiny, heavily Jewish accented lady whose life was so overturned by all the press about the Lemuel Smith case, and she came up to me and said, "Judith, how could you have done such a thing?" Just so. It upset her so much, but that was just because of all the press, and at the time I told her I was sorry, but I wasn't sorry really. I just tried to make her feel better. I don't remember whether I was whether there were any particular reactions on that. I have to tell you, I just want to spend a minute on the Hernandez dissent, because I have gotten a few. Every now and then I get something about that, and if I went to the drawer in my office, I could find this lovely message from a same-sex couple that had married, and quoted my dissent in Hernandez. And what I want to tell you is not about the time people have said that to me, but rather that first paragraph. And Robert, you were there. But I don't know if you know all of this, that Meaghan, our co-clerk, was going to be married, and I did Meaghan's wedding. She was marrying David, her very long-term boyfriend. And before I do a wedding ceremony, I spend time with the couple, because I try not to do many. I want each one to be personal and meaningful to me, and to them, to the couple. And when I sat with Meaghan and David, after they'd been together for a blissful decade or so, why were they doing this? And each of them told me what it meant to them to stand up before their family, their friends, an officiant of the state of New York, and to proclaim their lifelong devotion to one another. They said words like that, which just really touched me so much, and I tried to capture that in that first paragraph that we worked on so hard together. So that's kind of a personal standout, I guess, but there have from time to time been things, but they don't come immediately to mind.
What's your view of the proper role of courts vis-a-vis the other branches?
Well, that's a very difficult question. It's, we've touched on so many issues that are really profound issues, in profound societal issues, profound jurisprudential issues. When we talked about unanimous courts and divided courts, that's one of them. There's so much literature. Yes, well, I was going to sidetrack a bit and tell you that I just encountered yet another article. There are a lot of articles on the subject. But the issue about where the line should be drawn in our tripartite form of government, that's a hard issue to answer in a few sentences. You know, we have the three branches of government. We have the executive in the state of New York, represented by the governor. We have the legislature, the two houses, the Senate and the Assembly, each with its leaders. And then we have the judiciary. The two branches, the executive and the legislative, are political branches. They are elected by the people of the state of New York. They represent the popular will. That's what they're there for. And that is distinctly what the third branch of government, the judiciary, is not there for, not to just simply to discern and reflect the will of the people and respond to the will of the people. The third branch of government, the judiciary, is an independent branch of government, not linked to the other two, and it is there to guarantee the rights and privileges and that we have as people. It is so essential that the judicial branch be independent of the other two from time to time. The judicial branch is called upon to rule on things that are done by the other two branches, and all the time the judicial branch is called upon to assure that our rights and privileges are secured and our laws are enforced. And that's why we stand separate and apart. So how specifically do we draw the lines among us? You know, I've thought so much about that, and I wish I could come up with one single answer, that under A we do this, under B we do that, and under C we do that. And I've struggled a lot with it, and I can't tell you. And we'll take the issue of same-sex marriage, since that's the one we just had in the state of New York, where my heart was broken, as I told you, that New York could not be one of the leaders in the enforcement and recognition of rights which, to my mind, are secured by the Constitution of the state of New York. And I wrote that. That case came to us. And by the way, I should preface this by saying that judges, it's not as if we sit around up at the court and figure out, maybe we should pitch in on this issue, or, you know, we don't invent issues that we, just so that we can express the will of the judges. Parties bring cases under the law to the court. So we had that case, and the parties made all of their arguments, and they were very, very seriously considered. And I told you how sad I was that, to my mind, as I expressed publicly in that writing, we did not reach the right result. Fortunately, some years later, in fact, just this past, in the year 2011, the legislature saw fit to adopt a law recognizing the right to same-sex marriage. Now, there's a very good place to posit the question: where is the line between the judiciary and the executive or the legislature? Where do you put the line? If the court had gone the other way, was it transgressing the line? Yes, in the mind of critics. Critics would have said, oh, that's an activist court. The judges are just there to do their personal inclination. But no, I didn't see it that way. I think we have separate responsibilities. I cannot answer your question decisively by telling you exactly where the line is drawn. I can only tell you that, having spent 25 years there, I kept in mind my own responsibilities. I think I had a very good take on what my responsibilities were as a jurist, to protect rights and enforce the law, and I just did the best I could to discharge my own responsibilities, recognizing where the judiciary stands in the design of our government. And I've really spent a lot of time thinking about this, and I can't think of a more definitive answer other than we have to do it. We have to do what we think we have to do, period.
We've talked about your work on the Court of Appeals, both as associate judge and as chief judge. But when you became chief judge, you had to take on effectively a second full-time job. We're going to talk about the specifics of all the tremendous innovations you brought into effect. But first, thinking about all of a sudden having that job thrust upon you, having that responsibility, what was that like? How did you know what to do?
Well,
to
that's
run a
a
massive
really
court
good
system?
question. It's hard to know exactly what to do, and I do remember very painful instruction by our then chief administrator. The chief judge, the CEO of the state court system, gets to appoint a COO, chief operating officer, known as the chief administrator or chief administrative judge if it happens to be a judge. And I just want to say I was very fortunate that I had 3 fabulous chief administrative judges during my tenure as chief judge, definitely the right-hand person. I had Judge Leo Malonis as the first chief administrative judge. He left after a little over 2 years, and I think that's about the normal tenure for, usually they stay about 2.5 years. Then I had the blessing of Chief Administrative Judge Jonathan Lipman, today the Chief Judge of the State of New York, who stayed with me for 12 years. And after him, Chief Administrative Judge Ann Pfau, who just yesterday announced that she's going to move on to another position. So let me tell you, I was very fortunate once the dust settled a bit, and I did get Judge Malonis as my. You definitely need that chief administrative person there to do the chief executive officer role. But in addition, the then chief administrator, Matt Crossan, who died recently, he spent quite a bit of time with me. He came up for daily instruction. And I remember we would sit around until I would hold my head and say, Matt, I just can't take it anymore. That was how we did it. We'd sit for an hour, sometimes 2 hours. He took me on paper. I kept a notebook someplace, but I got daily instruction on just all the ins and outs of this very complicated court system. He was a terrific teacher. So there was that as one part, Matt's instruction. There was finding Judge Malonis as another part, which I did as quickly as I could. And the third part, which was a great help to me, was that Chief Judge Wachtler, in his last days, there was a huge ruckus about matrimonial cases. There still is. We just can't seem to do it, without huge amounts of pain. But he had appointed a committee on, to study lawyering in matrimonial cases. That's not the right name, but it's something like that. Judge Malonis, then a judge of the Appellate Division First Department, was the chair, and Chief Judge Wachtler had put me on that group. I was a member of that group, and that group was going gung-ho as some of these other events were going on. So I had the benefit of being on that commission. And I guess we were nearing the end of our work, and it was a very enlightening experience to be part of a commission. And I think that was probably literally the first of the reforms that were announced in my tenure as chief judge. We announced the matrimonial rules. We had a whole body of rules, a very good lesson for people in what can be done administratively. So I got the twofold lesson. I got the lesson from that commission. I got the lesson in administrative powers. I wasn't really as astute about the NYCRR, New York Code of Rules and Regulations, as I began. There's a lot of administrative authority. And I also got a very good lesson in process, what could be done through a commission. I got a third lesson, too, once we announced our reforms, which is the word pushback. People hollered and screamed and carried on when we announced what what the reforms were, and hollering and carrying on and screaming is the typical reaction to everything you try to change. I call it pushback. I became very familiar with pushback and even more familiar with push forward, because the change was necessary, change was good. It was just tough, people, and I shouldn't be too arrogant in saying that, because it's very easy to advocate for change when you're the person imposing change. It's a lot harder to advocate for change when you're the person who has to do the changing. But I got those early lessons in being the chief executive officer. And a little tiny footnote there on that last part too. I learned later on, in fact after the death of a very dear friend, Presiding Justice Dolores Denman in Buffalo, that when those rules were announced, you just didn't mess with Presiding Justice Dolores Denman. She was a person who knew the right thing and did the right thing, and just an absolutely fabulous human being. But later on, it may have been at her funeral, it may have been later, I learned from a matrimonial judge in Buffalo that when the stink began in Buffalo over the new matrimonial rules, Dolores Denman put her foot down and said, "I'll have none of that." And she got in her car, she took some matrimonial lawyers with her, and she traveled all through the 4th Department and said, "You are going to do these things. You are going to make this happen." And that's how it happened. And the truth, that's what you need to do when you try to change things. You just can't proclaim rules and go about your business. You have to be there on the scene to make them happen. So that was a little touch of my very, very early introduction to the role of Chief Judge of the State of New York. That second box of stationery that comes with Chief Judge of the Court of Appeals.
And then throughout your tenure as chief, you sought to innovate and improve in really all areas of court administration, often, as you've just said, overcoming substantial initial opposition to change, and became a national leader in so many areas of court and justice reform. So let's talk about some of them in particular. First, of course, jury reform.
Well, jury reform, there's a tiny little paragraph that belongs before jury reform, because chronologically, part of the pushback from the matrimonial lawyers was, why just us? What about the rest of the bar? The rest of the bar is, you can't just take this tiny percent of matrimonial lawyers and heap all the blame on us and impose these rules on us and do the rest of the bar too. Well, they were right about that, and you have to recognize when they're right, they're right. So that was another little commission that got, after the commission on the matrimonial lawyers, we did a commission on the bar, headed by Lou Craco. And the thing I'm suffering with today is, not really, that was where continuing legal education got started. That was one of Lou's recommendations, and so now I've got to get continuing legal education credit. Is there continuing legal education credit for this? No. I don't mean it. But anyway, you've used the word that is just music to my ears, in the sense that one of the things I brought with me as a litigator was acute sensitivity to the need to do something about the jury system in the state courts in New York. As I recall, I had even written something to Chief Judge Cook about that years earlier, because you couldn't go down there and be proud and pleased to see what was going on. So here at last I had the opportunity in my own hands. The truth was unvarying, that still something needed to be done. And I mean this on a couple of levels. So I'll start with the one that's really the responsibility of the chief judge, and that is operational, the chief judge of the state of New York. And I just didn't seem to be the system didn't seem to be operating optimally from the court system's point of view. But then there's the other aspect, which is the public point of view. Here is an opportunity to bring people in directly, probably the first time ever in their lives that people come into the courts. They read these dreadful things. Press is, by definition, poisonous. So they read these dreadful things in the papers about juries gone amok, awry. They read novels about jurors who are corrupt, and do terrible things. But why not bring them into the court system and show them a court system that works well, and show them a justice system that is really a justice system that operates for them? Why not maximize the opportunity through the jury system to change public opinion about the courts, which generally, if you stop people on the street, they'll tell you, it's not much. And then as a litigator, I had run into the jury system in unfavorable ways. I mean, things were ultimately okay, but let me tell you, it's a real sword over the head of the kind of corporate clients the law firms I was with represented, that they might have to endure a jury trial in the state courts of the state of New York. I remember one corporate executive saying to me one day that he was able to settle a case with a stipulation with his adversary that he would never again have to appear in the state Supreme Court of the state of New York. Now, that should never be. So I would say that was my first self-aware initiative, in the sense that I was on the Matrimonial Lawyer Commission, and the next one was the natural outgrowth of it, and terrific, and they did a great job. Lou Craco, a great job chairing that, and we put together a great commission, and everything they recommended we did. We were able to do all of those things, including, as I've mentioned, the continuing legal education, which I know bothers some people, but by now it's really inborn, and I think a very good thing, and all done by administrative change by the chief judge. Now, this jury thing, the challenge when you're putting together a commission is to get a great, really, really dedicated chair. And somebody popped to mind for me immediately, and that was a person I met, I think, while she was still in college or certainly law school. I met her through the general counsel of a client of a company I represented. And her name is Colleen McMahon. She was with a law firm called Paul Weiss in the city of New York. Really, I think she was already a partner, and to become a partner, I knew Colleen was great from the time I met her. Really watched her grow up. Colleen was the natural choice, and she was thrilled to do this. So she became the chair of the commission. I asked her, she accepted enthusiastically, and together the next challenge, after you get the chair, the next challenge is to find really a Zingo perfect group for the commission. And we wound up with like 30 people, I think. Colleen and I worked very hard on this. She brought with her from the firm a young lawyer named Roberta Kaplan. The first time I met Robbie, I drew Colleen aside and said, I want her as my law clerk. And Colleen said, keep your hands off her until this is finished, which I did. And then Robbie became my law clerk. So just tells you about Colleen and Robbie. But I remember being criticized. Everything, you get criticized for everything. And I remember some starchy letter from a judge. I think he wrote it to some paper, but they didn't publish it. Just shows how ridiculous our new chief judge is, a 30-person commission. That's just absurd. You'll never get anything done. But of course, that was key to getting, this was a big job all over the state. What we had at the time was about 24 automatic exemptions from jury service. So if you got a jury notice and you check the box for, say, a lawyer, a doctor, Christian Science nurse, person who wore a prosthetic device, person who made a prosthetic device, you could just care of children under 5, you just check the box, and then you were automatically exempt from jury service. So that depleted the list so much of the poor people who were on the list. What we developed was something called a permanent qualified list, I mean, we just knew the people who weren't wearing or making prosthetic devices or serving as Christian Science nurses or doctors or lawyers or firefighters or police or on and on on the list. And those people would be called automatically every 2 years because we've got a huge court system and we need a lot of people available for jury service. So they would be called automatically every 2 years, and they would have to serve a minimum of 2 weeks. I say a minimum because if they got on a trial that lasted longer than 2 weeks, they were stuck. But this was so unfair. It was unfair to the people on the list, and it was unfair to the people off the list. Colleen's, there were two amazing things about the project. I think having Colleen, having Robbie, having 30 excellent people, those were utterly essential. The two amazing things were that Colleen produced a report within 6 months, which is just breathtaking. And the second thing is it was called a blueprint for jury reform, and it had a bright blue cover. And indeed, it was an absolute blueprint for jury reform. And we followed that blueprint like the architect of some major building and the construction people. And we had a brilliant architect and brilliant construction people who followed to really make a very profound change. And maybe most key, but everything is key, so I don't want to diminish anything. Then head of the Senate Judiciary Committee was Jim Lack, now Judge Lack. And of course, getting rid of those automatic exemptions was a completely key to anything we were going to do to get rid of the permanent qualified list and open jury service to the public as it was supposed to be. But Jim at the time was very impressed by the report, and he began Senate hearings on these automatic exemptions. And much to his shock, nobody came. Nobody came. None of the groups that were automatically excluded, who had lobbied to get those statutory exclusions, none of them showed up to defend the statutory exclusions, believing, as in the past, that they were untouchable. But in Jim's mind, that led to the other conclusion, that if nobody cared, the Senate was going to abolish them. And it just, talk about breathtaking, the Senate wiped out all of the automatic statutory exemptions, including the automatic statutory exemption for judges. Now, Colleen's committee had recommended wiping them all out but one for judges. But Senator Lack, I wonder how he now feels as Judge Lack, but the Senate, they voted out, they wiped the slate clean, all automatic exemptions abolished, which was, in a sense, exhilarating and in a sense terrifying. We suddenly had more than 1 million really angry people that we had to show we knew what to do with, and that we had a good system in place that valued them and their time. That was a real challenge. That was a challenge. So it worked.
And you were called for jury service yourself as chief judge after
I
that,
have been from time to time called for jury service, but I have not made it onto a jury yet. My daughter has. My daughter, and recognizing that her mother was the chief judge, my daughter has served on a jury, and I love to tell the story there are two things. First of all, I am not her favorite judge, and it's not because she doesn't value me as a judge, it's because the trial she sat through from jury selection to verdict was presided over by Judge Juanita Bing Newton, and my daughter developed an undying respect for Judge Newton, the way she handled that case and that jury. And the second thing, the story I just cherish, is that I was in Albany at the time when my daughter called. And, we had just abolished all of the automatic exemptions, so we had all these professionals and a wide variety of people. My daughter called and said, "This is a great place to meet guys." And so I just thought that was terrific, too. Honest, I hadn't calculated that in advocating for the abolition of the exemptions. But, there were so many other things that were done, 1 million other things that were done. And just to give you one other little example, which is serious. The jury notices would go out, and I don't know, like 3/4 of them would be returned, and they would be just accumulated in the envelopes in a large room, just sitting there in a large room that, people just wouldn't, it says jury on the front of it, so they knew what to do. It's just ignore it. And nothing ever happened, period. That was the end. That was an easy way to get out of jury service. Just don't answer. Nobody ever did anything, which is pretty remarkable in this age of technology and all. And one small thing that developed, and I can't remember now, I think this was in the report too, the idea of resending the summonses, resending the notices. These were notices and not the second step. They would be resent. It's so easy with the computers and all to figure out a lot of things, and so they were resent a second time. They were resent a third time, and maybe even a fourth time, and the lack of response kept diminishing because we had a few very well-publicized instances where somebody who ignored a summons paid a price for it. You got called down there. You had to answer why. I mean, it's a violation of the law not to respond to the notice, and paid a penalty for it. I think maybe a couple of $100. I don't know that exactly, but I do know that what would happen when you got called down there before a judge for ignoring your summons was that you got put on jury service. And I remember one story, and these were publicized stories. So in addition to constantly resending the notices, we had some public awakening to the fact that you can't just throw them away. But I remember one story where a woman who didn't have any money asked, she was an opera student, and asked the judge if she could sing an aria from Carmen and then go on to her jury service, which he allowed her to do. But I say that was another way, that just to get people into the courthouse. But that, as I've said a moment ago, was a very small piece, hard to do, get them into the courtroom. But now that we've got them into the courthouse and the courtroom, what do we do to earn their respect? That was a big challenge, big.
And you did a lot of things.
A lot of things. What were some of the things? Well, I remember one day getting a call from my friend who's an editorial writer at the New York Times saying, Judith, you can't believe this, but I was down there for jury service, went to the bathroom, there's no door on the bathroom, and there's bar soap. You don't have that today. So I went down there, and she was indeed right. There were a lot of bathrooms that had no doors, and there was no bar soap. There was bar soap, so that I'm just going to the ludicrous extreme to tell you. We began a public awareness training of our wonderful court employees, wonderful. And in fact, the letters that I would get after some of these measures overwhelmingly were praising the jury personnel who, for their personal interactions and their caring. They're just showing some, interest in these people. Having a judge show up to welcome the jury pool, before just... So somebody cares about you. We're happy that you're here. The insistence that we bring people in for the shortest time possible, hopefully one day or one trial, not always possible, 2 days or one trial. We try that. Assuring that jurors, that some of the ones who sat for 2 weeks, they never would get questioned for a case even. That everybody who goes, at least, it should be relevant and important that you're there, that there's a prospect of your getting on a jury. Things like that. It just was raising the level of public awareness. Workspace, internet connections, more comfortable facilities. Somebody came along and some group put plants in the jury room. Somebody became attentive to painting the jury room. And little by little, just changing attitudes, changing public attitudes, staff attitudes, judge attitudes, everybody's attitudes. And I think, still people stop and tell me, it's changed so much, but I think it's something we constantly have to be attentive to. I used to tell the Kissimmee River story. I don't think I ever told you the Kissimmee River story, which was about a case I had as a lawyer where a client dredged the Kissimmee River for the Army Corps of Engineers, and then there was trouble getting paid because the Kissimmee River went back to its banks, to its ordinary banks. And I just always am fearful of the analogy to the Kissimmee River, because if you don't watch all the time, things go back to the way they were. So it's not only a matter of having better rules in place, and it's not only a matter of seeing that the rules are put into action, but it's also a matter of being out there all the time, seeing that the Kissimmee River doesn't go back to its curlicue instead of the straight line that was dredged. So that's the challenge for the chief judge. Great job. And we have a great chief judge.
You talked about the difficulty of eliminating the exemptions. Sequestration was another major piece of that.
Yes, sequestration. Now, there were just so many different pockets of resistance, and one came from court officers. And again, we have great court officers. When I talk about staff, I think of the terrific job that the court officers did and do, continue to do, how vital they are to the court system. But we had, in addition to this poor permanent qualified list, we had automatic sequestration for sitting jurors. If you were on a case where deliberations had begun, you were automatically sequestered, meaning you were taken to a hotel and kept overnight, not allowed out of the jury confine until you reached a verdict, which might sometimes make sense. There might be a need for it sometimes, maybe, rarely, where the judge's instruction not to listen to anything or consider anything or hear anything or talk about the case at all would be not sufficient. I think in the modern age it is sufficient, and overwhelmingly that's what courts do. But here we had a tradition where the jury had to be sequestered. Now that was a huge burden for people. Imagine if you had a family at home, and you're on a jury that's deliberating, and you have to be away from your home and your family for a couple of days. Why? And coincidentally, an enormous expense for the court system. Hotel and meal expense and overtime court officer expense. Big expense. So that was another issue that got worked out, very happily got worked out, so that automatic sequestration was eliminated, done away with. But I say there were a lot of things like that along the way, and it was just a project that for me was, I was so energized and so excited to be able to do that, and for the reasons that I've told you. But the principal reason, well, it's hard to say one versus the other, to have a great court system operationally, but just to get a much better public view of the court system, and coincidentally to educate the public a bit about what it is we do. We don't have enough of that in our schools or in our lives.
We'll talk about other innovations you instituted as Chief Judge, but before we leave the subject of the jury, do you want to talk about the ABA and the Postal Service? Oh,
absolutely, yes. That was one of the little side perks that was so terrific. As a lawyer, I used to be tremendously involved in Bar Association activities. The slate got wiped a little clean when I went on the court, and you can understand why, since there's not a lot of time to like you can't be on the executive committee of the City Bar Association or the board of the Legal Aid Society for conflicts reasons, but for time reasons too. But the president of the American Bar Association, which is an association of lawyers and judges, I think there are probably 500,000 or so members of the American Bar Association, and the president, there's a new president every year. The incoming president, spends a long time thinking about what his or her major initiative is going to be. And I got a call one day from this wonderful friend named Robert Gray from Virginia. He came to see me and was thinking of making the jury his initiative. What a great idea, really great idea. And he asked me to co-chair it, or to chair the initiative. Yes, there were co-chairs, right, 2 lawyers, and with Sandra Day O'Connor as the honorary chair. So now I just thought that was a great idea, and I accepted that and had a wonderful time doing that, chairing that group. When I discovered, just as a complete side, but I'll say it, Jeff Toobin was on that commission too. And I remember asking Jeff, how do we really get some traction for what we're doing? How do we make it big and significant? And Jeff Toobin said, you have to get Justice O'Connor to do something. And Justice O'Connor was so great. She was willing to do anything. So she came, and we went to Washington, D.C., and we kind of convened the jury and the panel, and she spoke to them. But the amazing thing, what I remember, is that there were 9 television cameras. This was just all over the place. And the bottom line message is our Supreme Court judges are rock stars. Nobody can get publicity like our United States Supreme Court judges. But anyway, there were lots and lots of issues, and in fact this continues to be, the jury issues continue to be special ABA issues. But in the course of the work that I did for the American Bar Association, I became conscious of an effort to get a stamp honoring jury service. People had tried from time to time to get a stamp from the U.S. Postal Service. They were brushed off, ignored, totally ignored. And the more we were ignored, the more important it became for me to get it. I remember seeing the stamp of the Muppets. Now, I love the Muppets, but we can get the Muppet stamp and we can't get a stamp honoring jury service. So I unleashed a flood of letters from the chief judges all around the country. They all wrote to the Postal Service. Every now and then the Postal Service would answer somebody. Most of the time they just ignored us totally. And finally, I got this one terrific lawyer in the city of New York. In fact, he headed up one of my commissions for a while on lawyers as jurors, because that got to be an issue, too. Everything gets to be an issue. His name is Greg Joseph. He's really just terrific lawyer. And I put in his hands the task of helping us get a stamp, because I was now determined to get a stamp honoring jury service. And Greg did a fabulous thing. He filed a Freedom of Information Act request under the federal law. Now, I think that cost him about $500 or more, because you have to pay for whatever documents it is that they're going to give you. But I didn't realize how powerful that would be until I saw, well, we got the stamp. I didn't realize how powerful that was until I saw Lynn's stamp catalog for the year 2007, where the Postmaster General is quoted as saying, the Freedom of Information Act request, that was the last straw. I couldn't take it anymore, and we were going to give them the stamp, period. I don't care. So we got the stamp, and it's a beautiful stamp. And in fact, regrettably, my husband died when there was a nationwide ceremony in Houston issuing the stamp, inaugurating the stamp, and they had a 5x5 poster of the stamp, which they gave me, and I left in the chambers of my successor. But yeah, that was getting that stamp. Unfortunately, it was, I don't know whether it was a 39-cent stamp or a 41-cent stamp, but whatever. It may have been 30. I can't remember the stamp. I'm looking at it here. It is an absolutely beautiful stamp. I have one of them. It may say 41 because I wrote over it, but whatever it was, we no longer are paying 41 cents for a stamp, and I understand we're about to pay even more for a stamp. But there is no more beautiful stamp than that one. That is don't you agree? Everyone in the room, Nick and Marilyn Marcus and Judge Mandelbaum, Robert, they're all shaking their heads. Yes, a really beautiful stamp, which I would think at this point is rather rare. If you can get it, hang on to it. I don't have it. Hard to get.
Problem-solving courts.
Problem-solving courts, yes. Now, Robert has put on the table the words problem-solving courts. I know exactly what he's talking about. I'm not sure we ever hit on the absolute perfect nomenclature. Is problem-solving courts, is that the absolutely perfect descriptive name? I don't know, but I know what you're talking about, so I'm going to go ahead and talk about them. And yesterday we touched on domestic violence courts when we were talking about some of the cases like Nicholson and some of the things that raised my own awareness to the need for essential reform in how we handle the scourge of domestic violence in the state court system. So what I mean is that fits under the umbrella of problem-solving courts. Maybe the problem being solved there is the problem of the court structure, the splintered court system. But I know what we mean by problem-solving courts, and I think I say that some states, in some places they're called like therapeutic justice, which I think we're not therapeutic. There's a kind of struggle for nomenclature, but let's lay that aside. And what I know you are talking about and what I will address are the instances where we don't just take in a case and manage it to disposition. That's hard enough to do, and that's overwhelmingly what the courts do. They have step 1, step 2, step 3, step 4, dispositions. We count dispositions, 4 million or more cases a year. We count them in, we count them out, and we move them along standards and goals, and that's traditionally what judges do. When we dispose of the cases, we've done what we're supposed to do. The problem-solving courts are a different avenue. The cases come in. Again, courts don't go out and find cases. If police arrest people, that's how, and people get indicted, and then they get criminal cases, or lawyers bring cases, and we get civil cases. Courts don't go out to discover problems, but courts have to deal with the problems. And I say the traditional way is to deal with them by taking the case in and managing it to disposition. The problem-solving courts are a different route, and it's turning the prism just a little bit to figure out whether the interventions, the court intervention, the time the court spends on the case can be more constructively utilized than simply disposing of the case, the issue. And probably the most typical example would be a young drug offender. I'll take the easiest case, not easy, but it most easily demonstrates what I'm trying to say, would be a repeat drug user, possessor, drug offender under the laws of the state of New York, who could be arrested and prosecuted, and in the end, maybe because the process takes so long, and it would be held incarcerated in jail, and then the sentence could be nothing more than time served, and then the offender goes back right to the same place and gets arrested again, and the process begins again and goes to the same conclusion until there's a sheet called a rap sheet, which is the sheet of the defendant's encounters with the court system that is 6 feet long. So problem-solving courts are an effort really to intercept, and instead of using that time to go through methodically and almost following the law less than maybe probing the individual, they try to reroute the person, take them off that pathway back to the Port Authority bus terminal and dealing the same dealing or prostitution or graffiti or illegal vending. I had my first exposure, this is still back in the year 1993, the year I became chief judge, when we were in the development of the Midtown Community Court, which is a structure on 54th Street between 8th and 9th Avenues in the city of New York. In fact, it's a building that on the front of it says Municipal Dist Court, or court, yes. And I think originally we had court houses around places, local places, until the dockets got so huge that it made sense only to centralize them. The only way the dockets could be handled and court business could be handled was to centralize the courts, which we did. But there was that vestige on 54th Street, and it was, at the time I became chief judge, there was an effort to make that a community court. And it was the pressure from the community that was driving this initiative, the theater owners, the business owners, who felt that the Times Square area, and this is basically the Times Square, the outer fringe of the Times Square area, right next door is a police precinct, that they felt the quality of life was so unnecessarily eroded by the way the courts really, well, first of all, by the conduct, obviously, but second of all, by the way the courts were handling this. They just saw an opportunity for the courts, with the community support and community assistance financially in every way, to make a more positive, what I call turning the prism and making a more positive intervention. And that was the origin of the community court, which was the first of the quote-unquote problem-solving courts. And I distinctly remember, I can fix a time, that it was October of 1993, that there was a ceremony with Mayor Dinkins where he handed me the keys to the court. That was the figurative, symbolic gesture that opened the Midtown Community Court. But in so many ways, it was so different. First of all, it's a six-story structure that had been, and obviously owned by the city, and occupied by a theater company, which now is on only one floor. They're still there, but they're on only one floor, and the Midtown Community Court has all the other floors. The court itself was vitally restructured, reorganized, rebuilt. And there are so many things about it that signaled how different it was, starting with the fact that it was a dignified-looking structure, and there was computer technology evidence, so that you would know, somebody being called would know when the case was being called, unlike just gathering in a room of how many hundreds. There were fewer people. You'd know when your case was being called, and so that was just the surface. Holding areas were glass instead of iron or steel or whatever it is, bars. But when I mention the technology, that's really the key, is that the judge, a specially chosen and specially assigned supervising judge of the court, had enormous information about the person, more than the judges, the wonderful judges in our criminal parts where these cases would normally come, would have. So that it became a much more, that the perspective was different on trying to intervene, not just to dispose of a case, but trying to use this moment of intervention as a positive, constructive intervention, to see that the person had the support and the services. A person who was willing to own up to this illegal activity and illegal life would have an opportunity to be connected. This is really the essence of it, to be connected to people who could help the person turn his or her life around. Family members, friends, caseworkers. If it was drug treatment that was needed, under court supervision, there would be drug treatment. The prostitution cases were handled differently. So the ground floor, as soon as you walked into that building, and to this day, as soon as you walk into that building, you see a difference. See, by contrast, the criminal courts of the city of New York in Lower Manhattan. But on the other floors, there were some floors, of course, for court staff and all, but there was a floor, I think it's the 5th floor of services. You'd be signed up for drug treatment if that's what you needed, pick up your welfare check if that's what you needed, courses in English if that's what you needed, connections to job training, connections to interviewing skills, and places you could go to apply for a job. I mean, just a really quite different approach that over the years has proved to be a very successful one, What the point is, when I've talked about rerouting a person's life, and I've ignored the point I should put equally at the top of the list, which is when you do something that violates the law, you have to pay a price for it. You have to be accountable for violating the law, and so accountability is also highest on the list of the judge in the community court. And I see, since I live in this area and work in this area, I often see people wearing Midtown Community Court vests and all, who are working on cleaning the streets and removing graffiti, and because very often the punishment, instead of time served, the punishment is a real punishment, and it's service to the community. And that is very assiduously watched, and people do their service to the community. And I've seen so many instances and remember so many instances of sitting with people, because I used to visit there often when I needed a lift. I don't mean in an automobile, an emotional lift. I would go up there to have a look and see people whose lives were genuinely being changed by a positive, constructive court intervention. And that was day one.